Hey guys, it's Squid. Welcome back to the channel. How's everybody doing this afternoon? I surprisingly didn't die during my workout. I felt like it though. That's the closest I've ever been to puking in a workout in like a year. Anyway, I hope everybody is doing well today. Hoy, it's a new adventure. Like it's a new adventure. So this is going to be a pretty quick stream. There is not a lot from this morning. There's just a response by Randy, which is 2 pages, and then a couple of emails. And Marcus King, thank you for the $4.99 super chat. It is very, very much appreciated. Hoy, we're just getting started. However, there's one thing I do want to talk about. We have heard a lot about Local Rule 7.1. Well, and I've had some questions about Local Rule 7.1. So we're going to read Local Rule 7.1. And Alley Cat, good morning, or good afternoon now. Holy crap, it's 2:15. Oh, Pam, hello. And D. Johnson, how are you doing today? And I don't know who else is going to show up for this, if anybody at all. This is like one of those random streams. But we are just going to get straight into it because I am not wasting any time today. Oh, and to the person who was DMing me earlier today, and it's hold on. It's that said, I amaze them because being a stay-at-home mom and all of that fun stuff. Well, I did forget to take something out for dinner tonight, so there's that. So don't if I am by no means perfect, but also the people who comment on my streams that I should get off the internet and play with my daughter. I was just thinking about this. Like, I'm on the computer maybe 3 hours a day. I am home 24/7, 365. I went to the gym today. Guess who I brought to the gym with me? Like, I don't. So for it just makes me laugh. The people who tell me that I need to get off the internet and play with my daughter. I'm literally home with my daughter every hour of every day, my entire life. Except for maybe when she stays home with her dad when I go shopping. In a couple of weeks, I'm having a girls' night. We finally all found a night where we all have a day off or some time together, and we are going to go do a ghost hunt in Savannah. So, like, we're going to go on a ghost tour. But that's my girls' night. Other than that, I've never spent a night away from my child in her entire life. So yeah, there's that. Thank you. Hey, Kasha. How are you? King Paco, how are you doing? All right, so we are going to get straight into, it's a pretty quick motion. It's only a couple of pages. It just makes me laugh because I'm like, y'all, like, these are the same people that would be yelling at me if I was if I had a 40-hour a week job, that I am not spending enough time. I need to stop working so much and spend time with my daughter. So, like, when people don't like you and people just want to try to troll you, those are the people in life that you're never going to make happy, because everything you do is always going to piss them off because they just don't like you. Oh, I laugh. I laugh. And when they do, usually I screenshot it and I share it with you guys, because if they want their 15 minutes of fame, well, I'm going to oblige, because I am just that nice of a person. Debbie Albert, Ghost Hunters, maybe you could find Bubbles, as he likes to ghost people. Thank you. And I appreciate everybody in here. I just find it hilarious. And it was just one of those, like, I just had that random thought that, like, these are the same people that would complain that I'm not spending enough time with her if I worked a 40-hour-a-week job. Or that would be saying I'm not contributing to my family, so I need to go back to work. There's no pleasing some people, which is hilarious. Hey, Bridget, how are you? Oh. All right, we are going to share this. There we go. I was like, that was delayed. You need mommy-daughter time at the gym, so what? Yeah, I need to get back into shape because holy crap. It's like, hold on, I just have to respond to someone. Hey, Mad Englishman. Not too many of us here tonight. Yeah, I know. It's only 100, not even 100 people. But we are going to get into this, and then we have 7.1 that we are going to discuss. Document number 10,998. Somebody asked me today how many pages I thought were in this. And I'm like, I said over 1,000, but I can't tell you. Like, I couldn't give you an exact answer. This is freaking ridiculous. All right, response to motion to strike. And you can tell it's a bubble, or it's not a bubbles motion because look, everybody's favorite word is in there, Gainesville. All right, response to motion to strike. Plaintiff Jeremy B. Hales, Mr. Hales, by and through undersigned counsel, responds to the motion to strike and states, 1, plaintiff filed a motion for sanctions, including judicial default, document 96, pursuant to this court's order, document 43. We will get into that. Plaintiff's motion for sanctions is a motion for judicial default and dismissal of counterclaims. This means it's a motion that would determine the outcome of a case or claim. Fair enough. Therefore, an attorney conference and certificate is not required. See local rule 7.1D. An attorney conference and certificate are not required for a motion that would determine the outcome of a case or claim. Moreover, defendant's motion is improper. This is because it is a motion filed without good faith to resolve the issue through a meaningful conference with an attorney for the adverse party. Defendant's counsel sent an email yesterday at 12:42 p.m. alerting of the proposed motion. Plaintiff responded at 8:33 p.m. stating, counsel, the motion requests dispositive relief, judicial default, and dismissal with prejudice of your 2 counterclaims. See local rule 7.1D. We will be seeking judicial default and dismissal with prejudice. There's a kicker. With prejudice of your 2 counterclaims on April 3rd. See Exhibit 1. Instead of a conference about this, defendant's counsel filed a motion at 10:05 p.m. An email or other writing sent at near the time of filing of the motion is not a meaningful conference. Local Rule 7.1b. Additional examples for April 3rd, 2025 are attached, and this is not exhaustive at this point. See Exhibit 2, hashtag Hales hates the truth, and hashtag Randy Shockett clown. Wherefore, plaintiff hereby requests the motion, document 100, be denied. Respectfully submitted. Shockett Law, certificate of service. All right, here we go. The subject of this email is Rule 7.1b, motion to strike. Counsel, the motion requests dispositive relief, judicial default, and dismissal with prejudice of your 2 counterclaims. See local rule 7.1d. We will be seeking judicial default and dismissal with prejudice of your 2 counterclaims on April 3rd. And then this is the original email. I will file a motion to strike. This is from Bruce to Randy. Counsel, I will file a motion to strike the motion for sanctions under local rule 41.1 for non-compliance with rule 7.1c. Please advise if you consent to striking the motion. If you thereafter wish to file the same motion after conferring, you would be able to do so with the certification, and thus the motion would not be susceptible to being stricken. Thank you. Somebody apparently doesn't understand the rules of the Northern District of Florida. I understand reading is hard. I do it every day. It's kind of hard. However, if you are going to, MaxLab has me blocked. So MaxLab is MaxLab, but he does not give me any documents. He does not alert me to any documents. Ever since I stopped talking to certain people, he blocked me. So please do not mention that name in my chat. I appreciate it. I would really, really appreciate it if he would not do that. Thank you. Anybody mentions anybody who's involved in the drama, I will time you out for 24 hours because I just not bringing that here. I get no documents from anybody. All the documents that I have, unless otherwise stated, I got myself. I don't do that. I am not, like I said, I don't, no. For everybody who's always like, that person, no, I get no documents from that person at all. Bruce Matskin, this was document 102 or 101-2. Yeah, Squid pays for these on her own if you have some coffee change. Yeah, I do pay for. They are only 10 cents a page, so they are not expensive. It just every time I check the docket, it costs at least 20 cents because it charges you basically all the lawyers' names and all the parties are a page, which is interesting. Nope. Patience Squid and get him good. This is a Facebook post because we all know that even though someone doesn't seem to understand social media marketing, they sure like to post on social media a lot. Exhibit 1. Like, oh, that was not alive. So my video of that I read the motion from this morning, that was not a live stream. That was a clip of a live stream. I live streamed this morning talking about the new case in Wisconsin that I'm going to be following. And then when I knew that this that document was posted, I read that document and then cut my live stream into where people can just see that document. That is not a live stream. That's a clip of a live stream. So that I thought I was tripping in the Matrix. In Soviet Russia, you don't become part of the drama becomes part of you. And I don't do dark magic, thank you. You know. I'm 100% positive the Judge C proves. Me too. And didn't I tell everybody? Okay, not to say I told you so, but I told you so. Like, not to say I know everything, because sure as shit, I don't know a lot. But, I don't hate him. Remember, I said he has me blocked, not the other way around. So remember that. Remember that. Just words are important. Hey, Andrea. I'm about 15 minutes behind, but here, and I don't know what the fuck worried about. It's the people got too much time on their hands. Yes, this is live. The other one was a portion of a live. I hate no one, for the record. I hate no one except for Bubbles. And slightly MLS, but I don't even hate MLS because that takes too much time and effort, and I ain't got that kind of time. Hey, baby girl, you want to FaceTime Grandpa? He just texted me asking if you could chat. Here, let me see your phone, please. Hey, come here, baby. You want to FaceTime Grandpa? Okay. Okay. Grandpa asked if you could FaceTime. Yeah. Grandpa. There we go. There we go. All right. Hey, Peachy. Oh. Hey, Timothy. No brain glitch. No brain glitch. No brain glitch. Hold on. I have to turn her volume down. Be right back. Alrighty. Yes, exactly. And it takes too much effort, and you can't hate anybody on the internet because it's the internet. It's at the end of the day, as real as we all try to be, we act different on the internet than we do in our everyday lives. So second time. The second video is a video. It's not a live stream. It's a cut of this morning's live stream, so that if you just want the information about what the Hales, you don't have to watch my entire hour and a half live stream to get that. I'm in bed recovering from foot surgery for 5 weeks and forced bed rest on pain meds. Excuse me if I get weird. No, make sure that you do some bed exercises though, because for every 1 day you're in bed, it takes 3 days to get that strength back. So even though you're on bed rest from your foot surgery and you're probably non-weight bearing on that foot, make sure you're doing some other. My OT brain kicked in. Sorry for the derailment, people. Yeah, exactly. And that's the thing. I just don't. It's just, I don't hate anybody. Do I like to talk to everybody? Nah. Yeah, Richard, if there is a drama within that is just stupid. I distance myself from everybody. I don't. Yeah, the pettiness is unnecessary. And I'm petty, but I exit stage left and I eliminate people that I just don't I don't have time for that. It's too much mental energy. No. It Huh? I was sent to Nomo in my life. Thanks. Oh. Okay. I don't hate anybody. Don't hate anybody. Never will. It takes too much effort to hate. Hate only corrodes the container it's stored in. I don't hate anybody. Just be more Tammy. Yes, just be more Tammy. Yeah. For every 1 day you lay in bed, it takes 3 days. So that's why if you work out all week, but you lay in bed all weekend or lay on the couch all weekend, that's why you may not be seeing a increase in your fitness because I was sent to Nomo in my life. Hope you're still here, KU Thunder. I didn't mean to make anybody mad. It is what it is. Yeah, hated and jealousy are just two emotions that they take too much internal effort. And it's at the end of the day, the world is too big and no one particularly cares about one person being jealous or upset or anything, because the world keeps on. You can be as upset as you want. The world keeps on turning. And it's like when someone is offended, the world keeps going and not a lot of people care. So being offended only makes the person who's offended upset. Everybody else just, yeah. Too much high school drama. And I'm always the type, for better or for worse, and I've had conversations with this about some people, that I just don't, ghost people is the wrong word, but I ghost people because if people start drama with me, and this is real life, this is not internet, always, Like even at work, like if people start like drama infighting at work, I stopped. Like I wouldn't like eat with them anymore. I wouldn't be rude, but I just made it a point not to associate, didn't text them anymore, eliminated them as like friends on Facebook. I just like, you cause drama or you have a dramatic life, and I just kind of, because I don't have time for that. I barely have time to do what I want to do, let alone to pay attention to stuff like that. All right, but getting back to the drama of all drama, the person who doesn't understand social media marketing but seems to love social media. And I barely use my Facebook. My Facebook is for like my people that I personally know and talk to. So like if people find my personal Facebook and send me a request and I'm sorry I don't accept it, it's nothing personal. It's that's where I post pictures of my daughter, and my family is on there, and my extended family is on there. So like I tend to only keep that close. Like all right, a short clip about my litigation opponents in federal court in Florida. Lawyers will know what I mean when I say that they are committing the worst Rule 11 violation you've ever seen. Oh, their lawsuit is I'm not even going to say that acronym because it's ridiculous. And stop trying to make fetch happen. Stop trying to make fetch happen. Their lawsuit is a scheme, protraction of litigation, and multiplication of proceedings to generate ongoing litigation related to storylines for YouTube content. It's the litigation along the way, not the outcome, that is the point of the lawsuit. The coming lawsuit against them will be historic. Hashtag Randy Shuckett Clown. Oh my goodness. Like, yeah, there's this too. Like this between this case and the Justin Baldoni Blake Lively stuff, like I don't I got enough drama on the YouTube with what I'm trying to read. I don't need any extra. I do not hate people. I dislike some people's behavior, so I distance myself from the drama and hateful behaviors. Yeah. Yes. The man is a hazard to himself. Yes. Yep. Oh, this is a really good point. That email takes away any chance that you mistype console whatsoever. Yeah. So, getting into a few things that this motion cites. Document 46. We're gonna do a throwback to document 46 or 43. I'm sorry. Plaintiff filed a motion for sanctions, including judicial default, pursuant to this court's order, document 43. So we're gonna go in the Wayback Machine. And we're going to look at document 43. So we're gonna stop this because I want you guys to see exactly what I see when I look something up on Pacer, so that we all understand what we mean when I say Pacer charges you for lots of stuff. We're going to go like this. So this is the docket sheet for Hales v. Preston, case number and everything. I'm going to go document specific because if I run the whole docket, I'll get charged. What's the math version of dyslexic? It's interesting. Oh, I don't. My name on here is Squid, so my login is Squid Pro Quo. So that's the only time I'll even dox myself is if I show billing. So this is what I mean. Every time you look something up, billable pages too cost 20 cents. So just one document or looking up one document on Pacer is 20 cents. Dyspraxic, that sounds right. I learned it when I was in college and I can't remember. So this is back, the Wayback Machine takes us back to December 9th. And then when you click on it, it's billable pages 6, cost 60 cents. And I'm not sure if I have document 43 in here in my, I do. Okay. So I don't get charged unless I click view document. Dyscalculia. Yes, that. It does worry me a little bit when Randy answers stuff so quick because my mom said come across wrong, but there is some things he didn't need to point out. It's this graphic. I'll have to look it up later. But I do have it on my computer, so I don't have to pay it 60 cents again. So we are going to stop sharing. 102 is out. Ooh, okay. 102 is out. So we are going to go back. And if you're on it, this is the related case. So there is no new documents in that case either, but I haven't, Jeffrey, my clinical knowledge of details and small things that you don't work with a lot is starting to fade because I haven't worked in a clinic since 2020. So 102 is out. 102. So I get charged 20 cents again. Reorder motion to strike. Oof. But the good thing is this does allow me to zoom in, where my computer, I just have to make it bigger, stretch it out. No worries, I got it. Hey, Harry, how are you? All right, this is the judge's order. Oh, it is ordered the 17th day of March. Happy St. Patrick's Day. I realized when I got home and I washed up and I changed clothes that I didn't put any green on. Hey, Lisa. It is ordered the 17th day of March, 2025. Defendant's motion to strike is denied due to the extent it sought to strike plaintiff's motion for sanctions. It is granted to the extent it sought an extension of response for the deadline for the motion for sanctions. So he does get an extra week. Defendant's response deadline is extended to 5 p.m. Central Time on March 25th. Because every motion or filing in this case seems to beget another motion of filing, the court will go ahead and preemptively state that plaintiff will not be given permission to file a reply memorandum in support of his motion for sanctions. So there is no need to file a motion asking. See Northern District of Florida Local Rules 7.1i, stating that parties ordinarily may not file a reply memorandum in support of a motion unless the court grants leave. Oh, not good with names. Thank you for the £2 towards the motion. Kitty, thank you. Oh, I appreciate that. Always remember the definition. Does it look like I give a fuck? Yeah, my give a damn is just broke. It takes too much effort. So me being the lazy person that I can sometimes be, when you got enough going on and you have to give attention to the things that need your attention, I am too lazy to pay attention to the things that don't matter. That's the best way I can describe it. There are some things my parents bring up to me for sake, and then I'm like, that's not important to me. That's not important to me. It's not on the brain. I got other things to worry about. It's not important. Yes, this right here. This judge is so funny. Stop filing motions and stop filing responses. I'll praise the book of Dilligaff. Hey, Yamaha biker. Yep, Randy filed, but also Randy didn't file a memorandum, and he kind of did, but he kind of didn't. I'm sure if he were to file a memorandum in support with, he would have a lot more case law. That's the word I was trying to find. Yes, he used the local rules in his motion, but at the same time, he did not, he didn't use any case law. Like, it was just a 2-page thing. I'm sure they would be more thorough. Yes, Bubbles getting denied again. Yep, judge only gave him until Tuesday instead of this Thursday, so he's got till next Tuesday. If you know what he's talking about, you know. If you don't, oh my goodness. It came out in the Johnny Depp Amber Heard case that Amber Heard took a number 2, took a deuce in the bed. Hi. Oh. Like, Johnny Red turned green, did Pat say, and will be hunting Razorbacks. Yeah, Amber Turd. I wish he would file another motion. Although Two Flea's gonna have a lot of. Oh my goodness! And I like I like crystals. Like, I have some crystals, but like crystals in the shape of body parts is not my thing. It wasn't a chocolate on that pillow. I have no idea, but somebody should find out. All right, but we have this. So everybody's been mentioning Rule 7.1, Rule 7.1, Rule 7.1, but not but we're like, okay, I always drop the kids off at the pool would be the the bathroom, but I guess campground would be oh God. Yeah. Denied. PPE is a guaranteed deuce in a box. Oh my goodness. All right. Oh no. Oh, thank you. Thank you. Like, she just brought the dark hat. There you go. Hey, Gary. Oh boy. All right. We're just going to get into this. What is Rule 7.1? These are all the local rules of the Northern District of Florida. So if you scroll up to the top, you can see it. And all I did was Google it. Now I have it saved on my computer. Local rules, Northern District of Florida. What do you want me to do? You want to put it on your head? There we go. There we go, cutie pie. Did you leave Grandpa in the other room? Yes. Yes. Oh. Hey. The judge denied Bruce's motion in part, where he denied the part of the motion to strike the motion for sanctions, but he approved it and gave Bruce a 5-day extension on his response. So, go there because nothing good ever leaves there. Ugh. Denied. I think that Bruce is like drank a whole gallon of Delulu lemonade. So this is all the rules, which is interesting because the last revision was 2005 or 14th day of 2005. And guess who signed it? That's the judge that's presiding over the other case. Not the one Judge Belatho actually has the case, but the judge over Belatho is Hinkle. So that's going to be an interesting AJ Raid. Hey, Raiders. Hey, Carmen. How are you? Yes, be sure to hit that thumbs up. We are trying to grow this channel, and we're we're not, I need to get back into what made YouTube fun, which is why we did last night's stream. So local rule 7.1, we are going to get back into it. But look at all these, like, this is probably why that somebody didn't read all of them. Bubbles got denied. AJ is alternate juror. If y'all don't subscribe to alternate juror, you should. Flashman, Gabby, can you drop AJ's link in the chat? Hey, AJ, how are you? Oh. And AJ has a wonderful Discord server too, where everybody has a lot of fun. And Gabby is the person who made my Discord server what it is. So she's on there a lot. 7.1 is motions. We will read what 7.1 says. And this is important. When you are a Pro Hawk Vice, you need to read the rules of the district you're in, because yes, it's still federal court. Say I don't know how many districts Massachusetts have, if it's just the East and West, or it's just one, because it's so small. It's KU Thunder, I know you didn't just call Gabby a tool. You better be joking. So 7.1b is what always brought up. Attorney conference required. Before filing a motion raising an issue, an attorney for the moving party must attempt in good faith to resolve the issue through a meaningful conference with an attorney for the adverse party. The adverse party's attorney must participate in the conference in good faith. The conference may be conducted in person, by telephone, and writing, electronically, but an oral conference is encouraged. An email or other writing sent at or near the time of filing is not a meaningful conference. So like when you respond, or when the attorney responds at 8:30 and you file a motion at 10, it's not a meaningful conference. When a conference is conducted in writing or electronically, an attorney ordinarily should be afforded at least 24 hours, as calculated under Federal Rules of Civil Procedure 6, to respond to a communication. This Rule 7.1b applies to an unrepresented pro se party only if the party is not in custody. 7.1d is brought up a lot. Like, it's True. Exceptions: attorney conference and certificate not required. An attorney conference and certificate are not required for a motion that would determine the outcome of a case or claim, for a motion for leave to proceed in forma pauperis, or for a motion that properly may be submitted ex parte. Guess what? Like, oh, thank you. I just figure we always hear Rule 7.1b, rule this, rule that. It's like, well, what does that actually say versus what the attorneys, because their whole goal is to spin things in their favor and to write motions that are, you know what I mean. Write motions that can persuade, brain fart today, persuade the judge in their favor. So sometimes they leave out certain things that they otherwise would bring up. And part of that is, what do these rules actually say? So Discord is like, for those of you who are on Megan's locals, Discord is kind of like a locals, where it's like an exclusive community. You need a link to join, but it's not paid. You can, there's different, in my Discord, for example, I have different case files. I have the link for my Discord in the description of this video. I have different cases that I'm working on. There's a general chat where members can just talk. I have a working on my fitness section. It's a lot. You can watch movies on there. Other servers, I don't, because my server is small and boring, in the sense of like, I'm still learning about Discord. I know that Flashfan has a Discord and he does some trial watching every, Flashfan, forgive me, every like Saturday. Hey, Missy. So it's yeah. Yes, there's this too. Yes. There's this too. This cat, you said it perfectly. I think Bubbles forgets Randy is in Florida and probably knows a heck of a lot more than BBB about Florida local rules. It would be the same way if Randy went to Massachusetts. I'm sure Bubbles knows a whole lot about how Massachusetts local rules are and courts work because he's from there. Tuesdays and Saturdays. Thank you. I wanted to say Tuesdays, but I was like, wait, you did it a couple days ago, and that's not Tuesday. That's because it was Saturday. Yeah, Discord is a modern day IRC where you can share screen, audio, video chat, and scroll back. You don't have to be present to see what's entered. Yes. Oh my God, I haven't heard anybody say IRC in years. But I have folders where there's just documents on cases I'm following. So like if you want to see Colin Griffith documents, you can click on the Colin Griffith documents thing and just see all the documents. There's not if he does know Massachusetts rules, he doesn't follow. Well, there's a different semantics. Yes. Yes, I am. All right. What other I'm looking at the motion and I'm seeing what other things were brought up in there to look at, because a lot of these things, like document 43 is in the Wayback Machine. Wayback Machine. Dan Davis, thank you for the $5 super chat. Randy would do his homework and still make Bubbles to click more. That probably, but I would expect that like someone from an area would know more about that area than, a visitor, no matter if the visitor studied or not. So there's that. Like I would assume that, but I don't think. But okay, y'all make me laugh. I love this chat. I love this chat. Y'all are awesome. So there's this. This is 82 pages of reading to read all these rules. It's not everything. And we don't need to go through everything, but so do I. I was on IRC. Come on. I remember dial-up internet. That's how I snuck out of the house. And my mom knows this now. So, yeah. And I'm pretty sure she knew it then too. But I used to call her up at work and say, hey, can I get on the internet for an hour? Dial up the internet, get on the internet, and leave the house. And not come back, and make sure to be back, because if I logged off on the internet, she would call me. So yeah. Oh, bye, Carmen. Have a good one. Lori Daybell trial should be a disaster to watch. Yeah, yeah. He was a workman's comp lawyer. That's a very specific area. However, we got to go back in the Wayback Machine, because document 43 was addressed in that motion. And I do have document 43 on my computer. So If I did, Jeffrey, I don't remember. That was a long time ago. I can't remember that far back. Document 43. This is 6 pages of fun from the judge. Share screen window from 12/9. This is document 43. This is what was brought up in the in Randy's latest motion. And I hate that it always adjusts me back to that other. Sometimes StreamYard. Ugh. All right, so we're going to go in the Wayback Machine. I had green on when I went to the gym. However, green, I got home and I changed and I didn't put it on. Yeah, I'm not sure anybody else would take it, knowing that there's all this extra stuff. So, and John P538. There's a lot of lawyers who barely qualify for the title. Yeah, there's some people, and I'm not a lawyer, so I can't judge completely. Speak of the Wayback Machine. There is somebody that commented when I first started my channel that said, because when I first started talking about this case, that I'm not a lawyer, so I cannot comment on anything. I'm like, oh, good Lord. Squid just does not play well with others. She has told you all time and again. Well, there's that too. Yeah. All right. We're going to read this going back to December to see why Jeremy brought it up, because we're on document 102 and this is document 43. So everybody get in your Wayback Machine. Order this matter before the court on defendant's motion for order to comply with subpoena to provide deposition audio. In that motion, defendants asked the court to require the court reporter who transcribed the plaintiff's deposition to release her backup audio file. At the court's discretion, defendants have filed the transcript of the deposition, document 42. Having considered the motion and the transcript, no response from plaintiff is necessary. Defendant's motion, which is unsupported by the citation to any authority, is not well taken. The court sees no need to require the court reporter to release the backup audio file. The transcript appears to be complete. There is no indication the court reporter was unable to transcribe portions of the deposition, nor is there any indication that the court reporter failed to fulfill her duties of accurately transcribing the deposition. Thus, the court sees no reason to require the court reporter to release her backup audio file, and accordingly, defendant's motion is denied. There's another denial. Hi, Squid Perco. I was curious who the heck you were. Hi, how are you? I am here. It's just me. See, that is the dilemma. Which is worse? Serious question. BBB for her lawyer, or Lynette is per se. That's $1 million question. Is $1 million question. Heroes Chris. What do I have? What I missed something. I don't. There's something that I missed. So Karen's books. We did hear from the judge. The motion was in part denied and in part granted. The extension was granted. The actual motion to strike the sanctions motion is denied. So, yep, or at least $286,000 question. Yeah, I read it already. Yeah, AJ's really sweet and really nice. I'm just me. Like, I'm just me. Oh, there's a lot of people in this world that are nicer than me. I can be kind of like gruff with how not trying to be rude, but things come across rude. See U.S. v. Austin, 6th Circuit 2020, explaining that when an audio tape is merely a backup to the court reporter's stenographic record, as here, the audio tape is the personal property of the court reporter, and there is no public entitlement to the audio tapes, except in certain criminal proceedings. What the transcript reveals is that the only person who behaved appropriately during the deposition was the court reporter. The behavior of counsel for both parties, as well as that of plaintiff, was improper. Because the improper behavior permeated the deposition and eventually led to its termination, the court believes that a partial redeposition of plaintiff is necessary. Given the contentious nature of this litigation, the improper behavior that plagued the initial deposition, the partial redeposition will be personally supervised by the court. See generally Ledwin v. Proman, Southern District of Florida, 2021, holding that because of the deposition misconduct, the defendant was required to sit for a new deposition that would occur at the federal courthouse under judicial supervision. That partial redeposition will occur at the U.S. District Court, 1 North Palafox Street, Pensacola, and it will last up to 3 hours. Plaintiff's counsel, defendant's counsel, and plaintiff will be required to appear in person for the partial redeposition. Defendant's counsel will be responsible for obtaining the services of a court reporter to transcribe the deposition. Because both parties share some of the blame for that need to conduct the partial redeposition, the cost of the court reporter shall be shared equally between plaintiff and defendants. The scheduling of the partial redeposition will occur by separate notice following the consultation with counsel, but the partial redeposition must occur no later than December 23rd, 2024. The court would also note several things that will hopefully help the partial redeposition go more smoothly. First, plaintiff is not permitted to refuse to answer any question except for those that inquire to attorney-client privilege or another type of recognized evidentiary privilege. See Federal Rules of Civil Procedures 30C2. Questions about plaintiff's business affiliations, contracts, and the names of business associates, customers are not inquiries into a privileged matter. Thus, there is no basis for plaintiff to refuse to answer such questions. Indeed, plaintiff has asserted claims of tortious interference with business relationships. His business relationships and the impact of defendant's alleged conduct on those business relationships are directly relevant to this litigation and are the proper subject of deposition questions. Second, defendant's counsel need to focus on asking questions about the claims raised in this litigation instead of attempting to instigate conflict by asking about unrelated matters involving plaintiff and defendants. Way too much time in the plaintiff's deposition was devoted to irrelevant information about people and events that have nothing to do with the claims in this case. Third, a deposition is a formal part of a federal court proceeding that is to be conducted professionally and civilly. See Mintner Court v. Club Condominiums, Northern District of Florida, 2021, recognizing that depositions are to be conducted in a professional manner. Name-calling, personal attacks, and obstructionist behavior has no place in a deposition or any other proceeding in this case. Experienced lawyers like the ones involved in this case should be able to control themselves and their clients, but they apparently cannot, which is why the court will supervise the partial redeposition. Everybody in this case is now on notice. If this type of behavior continues, there will be sanctions. This phrase right here, right here, like right here. Those sanctions will not be light. They may include stiff monetary penalties, dismissal of this action, and disciplinary proceedings against the attorneys. See generally Lee v. ESAP Portfolio Operating Lessee LLC, Southern District of Florida, 2021. Dismissing an action as a sanction for unacceptable deposition conduct. Thomas v. Tinico Packaging Company, 11th Circuit, 2002. Affirming disciplinary proceedings against counsel for, among other things, making demeaning remarks about opposing counsel's physical traits or demeanor. And recognizing that a federal court has the power to control admission to its bar and to discipline attorneys. This was important to read again because this was very important to read again because this was the turning point, I believe, in a lot of things, where this was ridiculous on both sides. And this is where I disagreed with a lot of people with this motion. The fact that I loved the judge in this moment, and I believe that nobody acted correctly and maintained decorum in that deposition. So this is paramount to this whole situation. He said before that there will be sanctions, and this is where it's like, okay, Randy's like, okay, y'all, like, you said there would be sanctions. Put your money where your mouth is. So he mentions 43 in plaintiff motion, filed a motion for sanctions, including judicial default pursuant to this court's order, document 43. Randy's not wrong. Randy's not wrong. The judge said there would be sanctions, so Randy filed a motion for sanctions because that crappy behavior stuck around. So it's it's a big thing. It's a big deal. It's a big, like, sanctions are a big deal. And I've had people say, is he going to get jail time, or I hope he gets jail time. I don't think he will get any jail time. I don't think he'll be held in contempt. I do think that he will have a hard time keeping his mouth shut, because it seems to be when someone is smarter than you, or may not be smarter than you as a whole, but when they know more about a particular situation than you do, it's best not to, it's best to just smile, nod, and learn something. But what I feel Bubbles is doing is thinking that he's the smartest person in the room. Bubbles reminds me of Sarah Boone. He thinks he's the smartest. She thought she was the smartest person in the room, would file a motion that made it seem like she was the smartest person in the room, and the rest of them were all idiots. And then when the judge said no, she would throw a temper tantrum and write the judge. It was ridiculous. But this is why I think that it'll be, I think it'll be monetary. If anything, it'll be monetary. And maybe, just maybe, he might lose the Pro Hoc Vice status. If he does, I don't know what's going to happen with Lynette and John. I don't know. I think they'll have to be pro se, because I don't know anybody who would take this voluntarily. And MLS, and don't dwell on it. It's MLS's fault. He started doing something that could have gotten Jeremy into a huge boat of trouble, and it all went downhill. That is true. But at the same time, this MLS tried to get LP and Jeremy on his live stream together. Yeah, MLS is the only other person besides Bubbles that's banned from this channel. For reasons, yeah, he's Pro Hoc Vice under another lawyer, but that's the thing with the lawyer is, like, yeah, all you need is for someone to vouch for him, to say, yeah, he passed the bar, and yeah, he's an actual lawyer, and, like, I think he's competent. It's one of those, like, it's one of those situations where I'm not sure if the lawyer who he's not technically under a lawyer. He just needed a sponsor to say, yeah, he's a lawyer. Yeah, he's competent, whatever. But I don't think that sponsor will get in trouble, because it's not his bar license technically. It's like you get a temporary, it's like a temporary bar license. Is the best way to describe it. No. That the Florida lawyer, like, Scott Stark is the lawyer for the state cases. So there's a difference between the state. Yes, Scott Stark was technically Bubble's sponsor, but like once you get that Pro Hoc Vice motion, it's not like if one attorney gets in trouble, so does the other. Because at the end of the day, it's not Scott Stark doing any of the or putting his name on any of the BS. If he probably sponsored another lawyer, it might be looked at like, but at the same time, it's not him. So, Scott Stark does not have to go before Judge Beletho. It's only once you get that Pro Hoc Vice motion, you're basically temporary. You fall under the Florida bar. Anything you do in that case falls under Florida bar rules or whatever district you get admitted to. So any good lawyer would never take Lacey's case. BB did not have a sponsor. He applied. Hold on, I have his Pro Hoc Vice motion. We will. Girl, stop. Can you stop FaceTiming me? I'm right here. Like, she's FaceTiming me, and I'm literally on the other side of the room. Oh, where is his Pro Hoc Vice motion? I have it. I know I have it. Hi. Hi. Stop FaceTiming me. I'm right here. She's FaceTiming me. She's literally right here. Hi, BB. Hi. Oh, Pro Hoc Vice Bruce. It's at the end because I didn't type. Hold on. Hi. Oh yeah. Yeah. Stark is the state lawyer of record in the thumbnails case and the other state case too. Hold on, BB. Yeah. MLS is a Michigan man who makes us stupid. Oh yes, and who has I had been saving that disciplinary record from MLS for months after he nope. The only attorney of record on the case for Lynette and John is Bruce, not Scott Stark. But here is the Pro Hoc Vice motion. So, I gotta make it bigger. Sorry, it's crazy small. All right. So, and he still didn't put all the way back in the day. Angel, we're almost done, BB. We're almost done. Then we're gonna go outside and play. All right. Motion to appear Pro Hoc Vice. The undersigned moves for admission. Pro Hoc Vice is counsel for defendants. Elemental P. And John Cook, the undersigned's attorney admission tutorial was completed September 3rd, 2024, and that's the confirmation number, which nobody cares about. The undersigned certifies that he is familiar with this CME ECF filing, which is the electronic court filing system. What, baby? Here. Oh, you want? Crazy girl. Yeah, and somebody commented on the earlier video about why is no one talking about the case, the disciplinary case against him. I cannot find anything on it when I Google his name. I find stuff from a couple years ago, but like nothing that people are talking about. And I don't. If I had those, if I had that information, I would talk about it, but I just don't have that information. Like, that's not, like, no one, like I said, I don't really share documents with anybody, and nobody shares documents with me. So anything that I have is stuff that I found on my own, because that's just the way things work out. Like I said, I don't play well with others, so people don't send me stuff because I'm just me. Like, I do my own thing. I'm looking. Hold on. She's going through videos. Sorry, some of your, I'm just going through the comments because I'm trying to find it. You were, Wordsmith Forge said I was wrong about the Oxford comma. Other than that, okay, if I'm wrong, I'm wrong. But I was told, or I heard Megan say that the Oxford comma is no longer needed, but that's just my so I'm looking for that comment because I really want to address it. It's not that I can't remember who said it. Hi. I really wish I could find it. I can't remember who said it, but if I had the information on it, I would. I thought the BBB bar case is from a 2022 case. It is, I think. This is how he has a standing bar case for his upcoming discipline. Not sure the date, but as soon as it's happening. If anybody can find anything like that, any information on it, email me because I can't find anything. Maybe I'm just not looking in the right places, but it's a kinetic case with Cordelia Jones. Sorry, I'm writing that down so I know what to look for. But if anybody has, Shizzy has it. I haven't talked to Shizzy in I want to say I haven't had the time to watch Shizzy in months. I barely have enough time. So basically the only YouTube that I'm watching right now is Bluey, Paw Patrol, and when I stream. Other than that, my YouTube is very limited right now. The weather's getting warmer with the house. Moving in family. Yes, moving in family leaves little time for anything else. You get it. All right. Speaking of that, oh yeah. Oh, thanks, Hazel. What's up, baby? Shizzy's on vacay this week. Maybe that's why. And I don't get notifications for anybody anymore. I have no idea. I watch Mo, and I still don't get any. Angel, no, we can't call Daddy right now. He is at work. Okay, when he gets off of work, we will call him. Okay, 7 minutes. All right, I have to get going. You want water? Your water's over there, baby. No. Okay, I have to go. I have to go figure out. Always. My VPN changes on a daily. I change my location daily. Hey. Okay, I got to go. We got to go see. If you want to, you can you drop it on a. Angel, come here. I don't know what you want. You want my phone, but then you don't want my phone. Oh my goodness. Bye, guys. You can drop it in a comment on this video. I gotta go take care of the little one because I'm not sure what she wants because she's mad. She's big mad. Y'all have a great day. Thanks for hanging out. Happy St. Patrick's Day. And I will see you guys tomorrow morning for Ruby Frankie and that drama. We have to get through that case. And we have to get through the Justin Baldoni lawsuit. And I'm sure there will be more of the BS with this situation because Bruce can't keep his mouth shut. So we will see what happens. Anyway, thanks for hanging out with me, guys. I love you all.